are listening to The Bell Post. This is episode 45 of The Bell Post. This is a little bit different episode because I'm going to talk about a debate that I participated in. I'm calling this episode David versus Goliath, the Great Debate, because we were approached about participating in a debate and we would be arguing one side of the bail reform issue, and then they would have someone from Civil Rights Corps participate and argue the other side of the bail reform, criminal justice reform movement. And if you don't know who the Civil Rights Corps is, this is the group that's been filing the litigation across the United States. They've also filed all the litigation in Texas, whether it's O'Donnell, Russell, Daves, Booth versus Galveston County. All of the cases that went to the Fifth Circuit in Texas were filed by Civil Rights Corps. Other cases from other states, whether it's Walker versus City of Calhoun, whether it's Sanchez versus Alabama, or the Little case from Louisiana, those cases were also all filed by Civil Rights Corps. And then there's untold number of other cases where, when we were first just hearing about this litigation, where they would file suit against the city, and then we would just be hearing about it when they were announcing a settlement because they couldn't afford to fight them. And so they would be announcing a settlement, and then that's when we first started getting involved. And so we were invited to participate in this debate, and I'm happy to participate in heated debates as long as they're, as long as they're civil. And I will tell you, this was the harshest debate I've ever participated in. I mean, now I've been called, really bad names in groups before, but those, I don't consider those debates. That's just, you get up and say your side of the argument, and then the other side gets up and says you're an idiot, don't listen to him, they don't even respond to your arguments, and so I don't consider that a debate. But this was a true debate. So in preparation for the debate, I would listen to multiple podcasts or videos from representatives of Civil Rights Corps, and it became very clear to me several things. Number one is, the founder of Civil Rights Corps, his name is Alec Castanis or something like that. I'm terrible at pronouncing long names, but let's just say Alex K. But I found a podcast where he was talking about the Walker versus Calhoun case before the decision came out from the 11th Circuit, talking about how they had opposed, they fought them, and that they spent all this money. The bail industry hired this really important First Amendment person to do an amicus brief, and how they just were throwing away money, opposing them because they were right, not realizing that you go forward, they got reversed. And so then I listened to several episodes or several videos of the person who was going to participate in the podcast. And both Alex and this other person, they used very toxic language. I mean, they were not there to have a discussion to find common ground. They were there to turn off debate because they called jails cages. I mean, who's going to argue in favor of cages? As an attorney, there are questions you can't ask of somebody on the witness stand because they're toxic. There's no answer to that question that doesn't make the witness look bad. And the best example in law school is the question, have you stopped beating your wife? Because if you say yes, then you're admitting that you used to beat her. And if you're saying no, then you're saying you're still beating her. And so that's an example of a question that you cannot ask. It is so prejudicial that you cannot ask it. And it became very clear to me that they were using language that was so toxic that it was intended to cut off debate. When you call a jail a cage, when you're saying we don't need police, that the police have a terrible background and they date back to all these really bad things, which are not true. But the purpose of those things are to just cut off debate, and you can't disagree with them. It's almost like this identity politics. If you are in a certain identity, you can't listen to our argument because of these toxic arguments that they're making. Also, it was clear to me in this preparation that all the videos I was watching were pre-rulings, or they were still continuing to use the same arguments even though they kept being reversed. So, this all started, let's do just a little quick history review. It all started when they filed the O'Donnell case. The O'Donnell case dealt in Harris County, but dealt with misdemeanor bail. At that time, Harris County used a bail schedule, and so there had been a previous federal court that had authorized the use of a bail schedule, and it was intended to process people more quickly through the jail. And so what you would do is you would be charged with a crime, you'd look to the schedule, you'd see what your bail is. If you could post the bail, then you could either do a walkthrough, you could be in and out very quickly. But if you couldn't afford that amount, you would go to jail. And at your arraignment, you were not given an opportunity to ask for a deviation from the bail schedule amount. In fact, the judge would tell you, do not talk. Anything you use can and will be used against you. And so you never had that opportunity. And so when the plaintiffs filed this lawsuit, they identified a procedural due process defect in the system. And so they filed suit alleging procedural due process, equal protection arguments. And, inside baseball, the judges offered them procedures really quickly, and that's not what they wanted. What they wanted was the whole system thrown out and replaced with simple release. Everybody's going to get a personal bond for a nominal amount, $100, no matter how many times you're arrested for the same charge. And so the judges said no. They went up, they had multiple appeals where the judges were winning. The first preliminary injunction that Judge Rosenthal issued was reversed. So she entered a new preliminary injunction, which was probably more harsh than the first one. It went up to the Fifth Circuit. The Fifth Circuit, in an extraordinary move, stayed it, saying that there was a substantial likelihood that the judges would win. And so they remanded, so they stayed that and to allow the case to continue to be briefed. And then after that, there was an election, and 15 of the 16 misdemeanor judges were up for election, and they were all defeated. They were defeated by judges who had a platform that they would settle the O'Donnell case and they would give the plaintiffs everything they wanted. I mean, even the local paper was saying, hey, we've spent $8 million in attorney's fees. We need to settle. We just need to give in because what we're doing is not right. And I would point out, since the settlement, they've spent over $100 million implementing the settlement and creating a system of complete chaos. So they entered into a settlement. They gave the plaintiffs everything they wanted, even to the extent where someone has to miss court 3 times before they can do anything to them. That was part of the settlement. And so, as you can imagine, we've had a lot of problems with O'Donnell. But that was their first victory. It wasn't from the Fifth Circuit. It wasn't from the appellate level. It was through really just plain politics and getting the public to vote in new judges, and then those new judges gave them what they wanted. And so they got a little cocky. They decided, we're going to go to Dallas County, we're going to file suit there, and we're going to ask the court to apply the misdemeanor ruling to both misdemeanors and felony judges. And that's exactly what happened. And so the federal judge in Dallas implemented pretty much the same preliminary injunction that Rosenthal used, and he applied it to felony judges as well. And then you've got the Russell case where the plaintiff's attorneys went back to Harris County and filed suit also to apply the misdemeanor ruling to the felony court judges as well. And then you got the Booth case from Galveston where I think the ultimate ruling there was that the county had to provide attorney representation for anyone when they had bail set. That was argued at the Fifth Circuit 3 years ago, and no ruling was ever issued. Okay, so those are the cases that are in Texas. So then the Daves case went up to the Fifth Circuit. There was 3 opinions issued by the Fifth Circuit. The first one was the panel decision, and they said, well, we're bound by Rosenthal, what she ruled in O'Donnell as to the misdemeanor judges, because we upheld that in the first O'Donnell appeal. But we are not going to authorize the extension of O'Donnell to felony judges. And so the big issue, the critical issue is whether judges were state actors. And so they ruled that the district court judges were state actors and could not be sued under 1983 case in a 1983 case. But they made a point of saying, like a couple of sentences, that if they had the issue as to the misdemeanor judges to look at anew, they may have come to a different conclusion than the first panel. And so that was kind of a signal to the defendants to file a motion for rehearing en banc, and that's what they did. So in the second opinion, which was the en banc rehearing by the entire all 16 judges from the Fifth Circuit, they agreed that we're not going to extend the misdemeanor ruling to district court judges, but they also reversed O'Donnell as to the misdemeanor judges. And they said anytime a judge is setting bail, they are a state actor for that purpose. And then then the only parties left were the sheriff and the county, and so the Fifth Circuit en banc remanded it back to the trial court for some findings on two issues. The one, whether the case was moot because the legislature passed SB 6, and number two, whether younger abstention should now be applied. And if you think about it, younger abstention kind of should be applied differently now because we've got the judges or state actors. They can't be sued in 1983 case. So why would you allow the plaintiffs to go around that ruling to sue and get the same result by just suing the county and the sheriff? And it's kind of, to me, I've always thought the younger abstention in that situation was a stronger argument because you don't want to allow them just to do an end run around the original ruling to get to the same result. So it went back to the trial court in Dallas, and the Dallas court said, no, I don't think abstention should be applied still. He applied the same analysis that he applied originally. Didn't make any distinction now that we had all the judges out of the case. We only had the sheriff and the county remaining. And then on the issue of mootness, he said he agreed that the case was moot. And so he sent those findings, or the court sent those findings back to the Fifth Circuit en banc. And in the third and final ruling in Dave's, the Fifth Circuit said, we're reversing O'Donnell as to abstention. We're reversing the trial court. We conclude that if there are procedures to raise these questions in the state court proceeding, that the federal court is required to abstain. Federal courts should not be trying to manage the day-to-day operations of criminal court cases. That's the function of the state. And then they also ruled that the case was moot. Now, one of the rulings in the last Dave's opinion was both Dave's and O'Donnell should have never been filed in federal court. I mean, that's as close as you're going to get an appellate opinion as a slap on the face to a judge, I think, and with all due respect. So with all that history of all these cases, then you have, the Walker versus City of Calhoun case, where we've already talked about it, where Alex was saying how they didn't have a chance. They won that case. In the Sanchez versus Alabama case, that was appealed to the 11th Circuit. Again, the position of Civil Rights Court was reversed. And so they have a 0% track record at the appellate level. Everything they won at the trial court has been reversed. Okay, so we get to our debate, and it's very interesting because we spent so much time talking about these cases that the moderator in the video decided to spend some time describing what the O'Donnell case is after we were finished. And I thought that was interesting because the argument that was being made by Civil Rights Corps is that we should follow O'Donnell. O'Donnell is the gold standard. They've gone to other states and they've argued that we should be following the standard of O'Donnell. But then the standard that they argued that O'Donnell set is not O'Donnell. So let's talk about what each one of those is. In O'Donnell, we've already talked about it is simple release. We're replacing a bail schedule with simple release. You get a $100 personal bond and you get it every time you're charged with this crime, period. You can't be held if you don't show up 1, 2, 3 times. And so, the DA issued a report very quickly saying the FTA rate seems to be over 50% and recidivism is increasing. The Police Officers Union issued a report reviewing 1 week's worth of dockets saying we're finding that the failure to appear rate's over 70%. And then HarrisCountyCourtWatch.com is a website, and their 2 years' worth of data was downloaded from the district clerk's website, and that data showed, on average, an 80% failure to appear rate under this personal bond, $100, simple release system that they had set up. And so it was very different from what they were arguing what O'Donnell said. What they were arguing O'Donnell required was an individualized hearing to determine whether somebody should be detained, and that before you had to do it within 48 hours of arrest, and you had to have clear and convincing evidence before somebody could ever be withheld or ever be held. I'm very critical of that argument. That's kind of like the New Jersey plan, and I would say that the New Jersey plan is a complete failure. But also, it goes to the very heart of who sets bail. In Texas, the person or party that's responsible for setting bail is the court. The court sets bail on an abuse of discretion standard, and the defendant can file a motion at any time to change the bail amount. They can also file a motion to lower it. They can also file a petition for writ of habeas corpus if they think the trial court's not being fair to them. So there's a lot of different protections built into the system for defendants. That's not what they're arguing. They're arguing that we should take away who sets bail from the judge and give it to the prosecutor and make it a clear and convincing evidence standard. They have to do their discovery within 48 hours of arrest. They have to give it to the other side. And, there are cases where we don't want to give out, or the state doesn't want to give out their evidence within 48 hours of arrest. We know they have to give it up before trial, but they don't want to give it up that quickly because they're still gaining evidence. They're still gathering evidence to go to trial with. We're not talking about bail. We're just talking about, the evidence of the case. And so, have that burden becomes a substantial burden on the courts. I mean, it slows down the system. If you think of the criminal justice system as a conveyor belt, on average, the same number of cases are added to the conveyor belt every day, every year. And so you've got to resolve that number of cases or your backlog is increasing. And, we just came out of COVID where we didn't do anything for a year, and we had fewer cases filed, but we had a lot of bad cases filed. And no cases were resolved. So we have a big backlog. And we're talking about changing to a system that's going to slow down substantially the criminal justice system. I mean, under analysis that I've seen, using that system for determining whether you could detain somebody would require twice as many courts to just resolve the same number of cases that we're resolving right now. That is not cost effective. Counties are not going to do that. And so that's going to just create a bigger backlog, more chaos. The more chaos you have, you lose accountability. When you lose accountability, then you have de facto decriminalization to prevent the criminal justice system from collapsing. And so that was probably one of our biggest disagreements until we got to the issue of crime. They were asking me, what crimes do you think our bail reform is causing to increase? And I said, well, if you look at the papers that I've written and the discussions that I've had, you would probably think that I'm focusing on misdemeanors because I talk a lot about misdemeanors because that's where a lot of the data is. But the point that I'm making is anytime you set up a system that takes away accountability for whatever crime you do it, you're going to have an increase in crime. And the basis for my argument on that is Sanchez versus Alabama. They lived under a preliminary injunction for 5 years for misdemeanors and felonies both. And during that 5-year period, the first period, a little 6 months, the criminals didn't realize there was a change. But during that time, they're like, ooh, they can't do anything to us. And they can't hold us. And so crime started increasing, and it became a substantial problem when criminals realized that this is not, that they can't do anything. And so once their case was reversed and they could re-implement accountability, then the mindset was changed. Crime started going back down. And so the sheriff told me in a previous podcast it took about 6 months after they won that case to re-implement a system of accountability and to change the mindset of the criminals in the county. So my takeaway from that is there is hope. You can overcome what Civil Rights Corps is advocating should be done and mandating in some places where people just can't withstand fighting them. But here's the problem. Civil Rights Corps adamantly said crime is not increasing. They said only the perception of crime is increasing. Crime itself is not increasing. And they said, we have verified, peer-reviewed studies that show crime is not increasing. So you can just disregard what's going on in California. You can just disregard $25,000 a day in shoplifting. You can just disregard the Nancy Pelosi federal building, which has just told all their employees work from home. It's not safe for you to come to work. You can ignore New York, that has rolled back their bail reform 3 or 4 times because of increasing crime. You can disregard the newest crime statistics in California, where they were saying there was an article that said public perception is that crime's increasing. The latest statistics from California say they have something to worry about. Instead, they're saying, there's no increase in crime. I mean, I couldn't wrap my head around that. I mean, what? I mean, that's the one thing we should absolutely be agreeing on, is that where these reforms have taken hold, that crime has absolutely increased. And for you to not acknowledge that shows that we really can't have a civil debate. We can't have a debate at all. You know, a debate is on the policy, not on the facts. We usually agree upon what the facts are. If the sky's blue, we all agree to it. But we couldn't agree to that. The person who was the moderator invited us both to send information to them so that they could post it on the description of the video. We sent our information. We sent the DA's information from Harris County. We sent the YOLO study from YOLO, California. We sent the Police Officers Union study report in Harris County. We sent Harris County Court Watch. We sent the California newest crime statistics, and none of that was listed in the description, and nothing was listed from Civil Rights Corps. So I don't know whether they didn't send anything, so they didn't want to just post ours, or whether they didn't post either anything I sent or anything they sent. But I will say the most contentious part of the debate was a debate over whether crime is in fact increasing. Now, I had a friend of mine, I asked them to listen to the debate, and I said, where am I wrong? What have I missed? And they made a good point. They said, well, they keep talking about violent crime. And so I'm like, okay, well, are they splitting hairs between violent crime? And if they're going to split hairs there, maybe they're saying, well, all this crime increase, we're not prosecuting that anymore, so it's really technically not crime anymore. I mean, if you want to know the best place to look for whether crime is increasing, the best statistic is car thefts, because insurance companies still require a police report before they'll pay off that claim. And so we don't have to worry about, okay, are they not reporting this anymore, or is this one just there's just crime is down but it's really up? We don't have to worry about that debate. The report on on car thefts is through the roof. For Civil Rights Corps, there's no other way for them to do it other than they're splitting hairs. So crime was up substantially, and now it's gone down a little bit. It's still elevated. So now they're arguing, it's down. It's down. So the best evidence I have on crime is the NAACP in Oakland, California, issued a letter to the local elected officials blasting them and saying crime is endemic and we need a state of emergency on crime. The DA came out and said, it's sad that the NAACP would be using the talking points from the other party. But the regional NAACP over California and Hawaii, they came out and said, no, you're wrong. Crime is a problem. The local association or the local chapter is correct, and we need a state of emergency on crime. So this little talking point that they did right before the election, 2 weeks before the election, where they were saying crime's really not up, this is just a talking point from the other side. I don't think that works this time. The reason why I think so is because we had a News Nation town hall about crime, and I think this is going to come from the mayors. I think the mayors are seeing their property, their tax values of their commercial buildings just go through the basement. If you look in San Francisco, there was an article in the last 30 days saying that buildings have been selling for 25% of their value, 30%, 40%, 50% of their value, and you can't pay. There's going to be some problems there. Either their taxes are going to go way, way down, or there going to be some defaults. Because the article also made the point that the occupancy rate for commercial buildings in San Francisco right now is 30%. That's not at a high enough level to withstand or to sustain any kind of note on the building. And so I think that the News Nation town hall showed that our mayors are the ones that are starting to call crime a problem, and even our inner city mayors. We've even heard some defend the private bail industry. I mean, think about that for a moment. You've got Illinois still pushing to get rid of anything but simple release. You've got New York starting to pull back. They've rolled it back several times now. You've got other states that have put their toe in it, now rolling it back or have rolled it back. You've got California that voted it down, but still LA County has now implemented it. You've got craziness all over the place, and you've got a mayor from Durham, North Carolina, saying, I used to be a judge, and until you have an alternative to the private industry that has the same low failure to appear rate and has the same level of accountability, then you don't have an alternative. I think that's probably sums up the debate we're having right now, because the simple release mechanisms that are being tried at the push of Civil Rights Corps are not working. I mean, they have an 80% failure to appear rate versus less than 10%. I mean, you can see the chaos that would create. And so you're seeing the result. And so they can't acknowledge that that's the impact of what they're arguing. So they just have to say, no, you're wrong. That's just a perception issue. So what's my takeaway from this debate? My takeaway is it was very heated, and there was no common ground. No, I don't think there was any. Well, I'll take it back. There was one common ground. The Civil Rights Corps representative admitted that there was a disproportionate amount of crime being committed on the black community. And that was because I pointed out that 50% of all murder victims in the United States are young black males. And by and large, the people that are murdering them are from the same demographic. So why are we favoring young black male murderers over young black male decedents? And I pointed out that was a huge concession, because if you're conceding that crime is being committed at a higher than normal level on that community, then you have to agree that it's also being committed by the same demographic, by and large. And so that's the problem. If we have a disproportionate amount of crime, that's going to hurt these communities as crime goes up, because they're disproportionately being affected by crime. And what's their response to that? I feel your pain. Civil Rights Corps says, I want people to be safe, but they don't have any alternatives. They have no plan. Their plan is, we don't need police, we don't need jails, we don't need prisons, we just need to provide housing, we need to provide food, and we need to provide medicine. And then we won't have these problems. And I'm like, wait a minute. I'm going to give you the benefit of the doubt, and I'm going to say that's well-intentioned. But that doesn't address at all gangs, organized crime, or career criminals. In fact, those people flourish in that system because you're tying the hands of judges, or you're getting rid of them. So there's no one to stand up to them, and they just see that for what it is a green light to commit as much crime as they want. And the problem is that's not sustainable. The public will not stand for that. The public will fight back. And so my takeaway from this debate is that the current course, and you're seeing it across the country, is not sustainable. And Civil Rights Corps is the party that you can trace these policies. They were the ones advocating for them, and they haven't worked. I don't think they've worked anywhere. They even argue that Harris County is the place you can look to see a system that works. And we can't even agree on whether that's true or not, because everyone in Harris County, everyone in Texas, everyone at the Texas legislature would say that's not working. In fact, I would say Harris County is driving state policy in the opposite direction on bail reform right now. And yet Civil Rights Corps says that's the shining light. That's our example of the way bail should work, and that is working, and you should use it across the country. Not even a concession that there is a disagreement on whether it's working. Not even a concession that some people think it's not, like the Democrat DA in Harris County. Instead, we just have this disagreement, not on policy. We have a disagreement on just facts. Okay, you can't compromise when there's a disagreement on facts. You can't compromise with people that say your facts are wrong, my facts are correct. I mean, you can find a compromise on policy, but only when you agree about the facts. Civil Rights Corps won't agree on that right now. And so why is that? They've raised over $30 million advocating these arguments. I don't think it's about anything other than just keeping their donors funding their litigation, funding their lifestyles. I think that's what's going on here. And I would encourage you, if you want to listen to this very heated debate, then follow the link in the description of this episode of our podcast, and you will be amazed. It was a lot of fun. It got heated, and it got really heated at the end. And I would encourage you to go and find out how the David versus Goliath debate ended up. Thank you very much for listening to this episode of The Bell Post. Thank you for listening, and come back for the next episode of The Bell Post.